Hello, my name is Mark Lassman. I'm a U.S. trial attorney as well as someone who's worked more than 20 years internationally. Currently, I am living in Japan, and what I'd like to do today is to address Japanese law students and talk about the subject of effective cross-examination, giving some basic concepts. Now, what we'll be covering in this video are the basic purpose of cross-examination, essential practical rules for cross-examination, simple English phrases for courtroom use, common objections that you should expect during cross-examination, and most ultimately, how to create and perform a short cross-examination in English. So let's get to it, the introduction to cross-examination. So cross-examination is controlled questioning, which should be short and focused. It should be designed to gain useful admissions and designed to weaken unreliable testimony. So in essence, direct examination, the witness is going to be telling their story. The witness is the star. The witness should be doing most of the talking. So those are a situation where you'll be using open-ended questions so that the witness is free to speak. In contrast, during cross-examination, it's the lawyer controlling the witness. The lawyer is the one who'll be doing most of the speaking. So therefore, it should be mostly closed-ended questions. And what I mean by closed-ended questions are questions that can only be answered by yes or no. Your cross-examination should always have a clear purpose. Every question needs to have a reason. There should be no excess questions. The possible goals that you should be thinking of: trying to obtain favorable facts, things that are good for you, for your case. How to limit harmful testimony, meaning if something was said that was not good for your case, you try to limit that. Show inconsistency. For instance, if that witness or another witness has said something different previously and you want to highlight that during the testimony. Expose uncertainty. For instance, if the witness doesn't have a clear memory or something along those lines. Reduce credibility, meaning that if the testimony or the evidence for some reason shouldn't be believed. And finally, to support your theory of the case. Theory of the case is a term we use in Anglo-Saxon legal systems to mean what you're saying should be paid attention during the case, what you think the case is all about. So always avoid asking questions just because. Don't ask unnecessary questions, questions you don't absolutely need to ask just to be friendly or anything like that. Cross-examination, always have a clear purpose and your questions should have a reason. Repeating facts that should already hurt your case, it's always avoid. If something bad is said, don't get up in cross-examination and then have the witness repeat essentially what you were trying to mitigate or listen to. So never repeat facts that already hurt your case. So when we're thinking about cross-examination, when you're thinking about writing a cross-examination, what are the types of things that you should be thinking about to include in your cross-examination? So were there any prior inconsistent statements? Meaning, did the witness at some point say something different than what they're saying at trial? That's something you have to pay attention to and include in your cross-examination. Does the witness have a bias? Is there some relationship or something? You're only saying this because this is your best friend and you're trying to support your best friend. Does the witness have some reason to be testifying the way they are testifying? Poor perception. So for instance, was it at night? Was it dark? Was it raining or something, so that maybe the witness has a reason that their memory is not that good. Faulty memory can mean things like it's happened 2 years ago and maybe in between many things have happened. So let's say I'm investigating a case. It's from 2 years ago, and in between that time, I've been on 50 other cases, so sometimes I'm not going to remember. So is there an issue about potential faulty memory? Contradictory evidence. For instance, is there things out there, reports or other things that actually contradict what this witness is saying, so that it's not possible to have happened on that date because you have evidence to show that your client was somewhere else? So the purpose of cross-examination is not to embarrass the witness. It's not a drama that's on television or on in the new movies. You're not trying to embarrass anybody. The purpose is to try to weaken reliability, which just means your purpose is to try to take bad information and to show that maybe it shouldn't be trusted for these reasons that I've already been speaking about. During cross-examination, you have to decide documents, if you're going to be using documents. Documents can be reports or other such papers or, receipts and things like that. So documents can be important because documents can lock witnesses into facts. So for instance, if you're reading from the witness's report, a report that the witness wrote, for instance, a police officer, you can lock them into the facts because you have this in the report. It happened on this date. You said you arrived at this time. You can expose contradictions. So if you're looking at the report or the document and the witness is now saying something different, you can read, well, you wrote your report here, and in this report, it says something different, and that's a very effective tool. It increases precision. Again, if this is something that happened 2 years ago, and the witness maybe doesn't remember that well, but you have a document or something from that time that was created, you can say, well, you wrote this report 2 years ago, you wrote everything in the report, and what you wrote was this, right? And so you can increase the precision of the witness and then reduce escape opportunities, which just means if you have the document in front of you, the witness isn't going to try to argue too much with you because you have that document. But you have to be careful because overusing documents can be a problem as well. You don't want to use documents too much because it can slow the momentum of your cross-examination. You want your cross to have a rhythm. Question, answer, question, answer. And if you're fumbling through documents or whatnot, it can kind of slow down your cross-examination, which sometimes you don't want. It can be confusing to either the judge or the jury. If you're flipping through a lot of documents, it can become confusing for people because you're just messing around with documents, referring to this document, that document, and they don't really understand what you're trying to say. And then it can reduce dramatic impact. So if you have a good point that you want people to understand, again, if you're just flipping through documents or you're staring at your document, not even looking at the witness, and you make your point, it can kind of reduce the dramatic effect of what you're trying to do. So again, your cross-examination should have a rhythm. It should be short questions that require short answers. Yes or no questions, yes, no answers. And there should be this feeling of moving forward from one point to the next. And so that when you write your cross-examination, when you create it, you should be moving from A to B, then conclusion C. There should be this feeling that you're moving towards a point or something that's important. Long pauses and disorganization, if you're cross-examining and for some reason you take a long time in between questions or you seem disorganized in what you're doing, that can reduce your impact. So you have to be very careful to keep things as simple as possible, keep things moving. Okay. Always end strong. The point being, whatever your most important point is with that witness, always end with your strongest point when you're talking about anything that's important with the witness. End with the strongest point, because a strong point increases memorability. So if you end with your strongest point, people are going to remember that more. And so if you begin with your strongest point, they might forget by the end of your cross-examination, but you have to end with your strongest point. And the opposite is true also, that if you don't get a good answer, don't end your cross-examination with a bad point or on a weak point. If something bad happens for you, think of another question. Just don't sit down after having something bad said. Just think of anything else to ask, and then you can sit down, but don't end on a weak point. So always try to end on a strong point and never end on a weak point. So here's some of the core rules of effective cross-examination. Use closed-ended questions, which is our leading question. So what that means is cross-examination is generally controlled questioning. So good cross-examination questions suggest the answer. You woke up at 10 o'clock in the morning, correct? So you suggest the answer. And it should contain one fact. You woke up at 10 o'clock in the morning. Always try to only have one fact in each question. Otherwise, it can become confusing. And then your question should always call for a yes or no answer. That's how you control. You woke up at 10 o'clock in the morning? Yes. Then you had breakfast? Yes. And so that you're in control of the questioning if you're using these yes or no questions. So a good cross-examination question. You were sitting near the window, correct? You were sitting near the window, correct? The cafe was crowded, right? The cafe was crowded, right? So those are good questions. One fact, very short. So bad cross-examination question would be like this. What happened next? That's an open-ended question, which means you're not sure what the witness is going to say. Or can you explain what you saw? Again, these are open-ended questions. So you should always have yes or no questions. Don't ask open-ended questions. What, where, when, why, how. You should always be asking questions that only have a yes or no answer. Open-ended questions, the problem with open-ended questions is that they allow the witness to explain too much or to repeat harmful testimony, bad things. If the witness said something bad for you and you ask an open-ended question, it gives them a chance to just say it again. It can let the witness gain sympathy. So if for whatever reason the witness maybe is not believable, but the witness can then have the chance to talk to the judge or the jury and try to gain their sympathy. Or if they realize that they've said something badly, if you just ask open-ended questions, they can then go back and try to change it or correct it or make it sound better than it is. So usually what you should do is avoid, as I said, questions like why or how or please explain. These are very open-ended and you should try to avoid such questions. Rule number 2, never ask a question you don't know the answer to. This is something that's so important. I really have to emphasize, don't ask a question you don't know the answer to because it can become a disaster. And why? Because unexpected answers can damage your case. If you don't know the answer to the question, then you don't know what they're going to say, and they might end up saying something that's terrible for you or your client. And so never put yourself in the situation where you don't know the answer to the question. So it's better to only ask about weak points that you already know. If there are some issues that you think are strong for you, just ask about those, but never ask a question you don't know the answer to. Another important rule, do not ask the one question too many. And so what that means is a lawyer, you might be doing a good job with what you're doing and you're getting everything you want to say, and then you want to go one step further and try to have the witness make your argument or have the witness make some big I did it, I'm the killer or something like that. You always want to try, avoid trying to make that extra step. Only ask for what you need to get for your case and then stop there. What I mean by that is just get the facts that you need, and then later you can argue and later you can make the points. So only get what you need. So I just want to give you an example of what I'm talking about. So let's say your question is, you never heard the defendant say, I did it. You never heard the defendant say, I did it. And then the answer is no. No, I never heard the defendant say, I did it. Stop there. You stop there, because the dangerous extra question is, oh, so you're not sure the defendant did it at all, are you? You want to start to try to make your argument to the judge or to the jury. You're trying to make your ultimate point. But then what will end up happening often is that the witness will just say, no, I'm completely sure that this guy did it. I'm positive, So instead of just saying, oh, you didn't hear you never heard him say that he did it, correct? No, I never heard that. And then you stop, because later you can say yourself, you can argue to the judge or to the jury, he's not sure that the defendant did it because he never heard it. But if you ask the question, then more often than not, the witness will not give you the answer you want and actually ruin the point that you're trying to make. Simple, don't argue with the witness. Stay calm, stay controlled. Avoid arguing or long speeches or emotional reactions. The judge won't like you. The jury, if there's a jury, they won't like you. If you start arguing with the witness, nobody's going to like you in that situation. So never do that. Short questions are stronger. So a good question is, you never heard the defendant say anything, correct? You never heard the defendant say anything correct. A bad way of doing this is to have a confusing question. So despite all the confusion and the large number of people in the store, you still want us to believe you clearly heard the defendant say it. It just gets confusing. So you never heard the defendant say anything correct? Short. Make everything short. Something that is also really important, and every young attorney makes this mistake, is never write out a script. When I say by that is don't write out your cross-examination word for word where you're just going to be reading it as a script, because it will become really difficult. And what ends up happening, well, for instance, what you should do is write out bullet points. Late at night, bad weather, no glasses, you didn't have your glasses. You should write out just bullet points, key facts, or topics, because if you start trying to write out a script, number one, it sounds unnatural because you're just reading something and then you said this and then you said that, and it doesn't feel like it has any impact. And then what happens is if the witness says something that is not in your script, you start to panic because all of a sudden your script is gone because the witness said something different and then your script doesn't apply anymore. So you end up getting stuck. And so writing out a script can really limit you. And then maybe even the worst thing is if you're just writing out your script, you're not listening to what the witness is saying because you're reading your script. So never write out a script. As I said, just bullet points, bad weather, no glasses, too many people around, just so you know what question you want to ask. And this way you can be flexible depending on how the witness answers to be able to continue with your examination. And always remember to listen. It's a funny thing to say, but you can be so thinking about what you're going to say next that you end up not even listening. And so many inexperienced lawyers will just focus on their notes and not really listening. So a good cross-examination, the lawyer is listening actively. You're actively listening to what is being said. And then you can adjust your strategy in real time. Let's say you get something in the end, the witness says something really strong for you and you weren't going to finish your examination, but you realize this is a very strong place to end. You can just decide to end right there if your other points weren't so important and you all of a sudden got everything you needed. So you should be able to listen and you can adjust your strategy in real time. And then if you do need to follow up, be careful and only when it's useful to do such things. I just want to go in very quickly and talk to you about some essential English phrases for cross-examination. So at the beginning of your examination, you want to say something like, good afternoon, I have a few questions. Please answer yes or no. So you're trying to instruct the witness how they should be answering your questions. So I have a few questions. Please answer just yes or no. And then your questions can be phrased, you got up at 10 o'clock in the morning, correct? You got up at 10 o'clock in the morning, right? And so correct and right, that's the way you make yes or no questions. You make the statement, which is whatever fact that you're trying to get. The store was crowded, correct? The store was crowded, right? And so that's how you should be creating your cross-examination. And then also, is that true? You can also use that as a phrase too. It was very warm that day, is that true? And that's just another way of making a statement a yes or no question. Now, if the witness is starting to speak, not answering your questions, for instance, or somehow behaving outside of what you're trying to achieve, here are some phrases that you can use to help try to control the witness. Just yes or no, please. So if you ask a yes or no question, you got up at 10 o'clock in the morning, correct? And the witness just saying, well, I was sleeping late because I went in late last night. And if they're just not answering your question and you just wanted a yes or no, so you just say, just yes or no, please. Just yes or no, please. Or if the witness is talking about something that doesn't actually apply to what you're saying, you're asking a question and the witness is saying something different, that was not my question. That was not my question. So you got up at 10 o'clock in the morning, correct? I was working late and then the night before, and then I ended up going out somewhere, and they're just talking about whatever. You just say, well, that was not my question. you got up at 10 o'clock in the morning, correct? And so you can bring the witness back to your questioning. Please listen carefully. Again, if the witness is just not answering your questions, you can say, please listen carefully. Or let me repeat the question. Let me repeat the question. So again, if the witness is not kind of responding to what you're asking and talking about something else, it's a way of controlling the witness. And then now, if also when you're making your cross-examination, you're trying to confirm facts. So let's say you're setting up your question. So you can say, you stated earlier that you got up at 10 o'clock in the morning. Yes, that's correct. So you stated earlier that, so you're confirming the facts so that you can move your cross-examination along. You testified that, it's another way of saying the same thing. You testified that you woke up at 10 o'clock in the morning. You agree that, again, another way. These are all, you can use these any ways. It's not one or the other is not better or the other. So you agree that you woke up at 10 o'clock in the morning. And then ultimately you can say things like, you did not actually see blah, 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 nantoka, nantoka, correct. Or you did not actually hear nantoka, nantoka. So that's just a way of confirming the facts. You didn't hear the defendant say, I did it. Or you didn't see the defendant steal the book. Something along those lines. Now, let's just very quickly talk about common objections. And different legal systems have different objections, but these are very common among almost all legal systems. And so let's just talk about, in objections, the point of objections is to stop improper questions. People are questioning that are incorrect. You're trying to protect the fairness of the trial and also preserve whatever rules of evidence you might have. So those are the reasons for objections. So let's just talk about a few common objections. The first one is relevance, kankinai. So this question is completely irrelevant. If you're talking about, did you see in the store whether the defendant, and then you ask the witness, what kind of music do you like, or something that just has nothing to do with the topic or the subject. Or most often it's something that you want the other side is trying to say about the witness, and you can say that it's irrelevant. So what music do you like, or something along those lines. So the phrase that you would use is objection relevance. Objection relevance. So if the question is something that doesn't have a bearing, it's just not important, or really it's not helpful, and it has nothing to do with the case, you just say objection relevance. Kankinai. Hearsay, which is when a witness repeats another person's statement to tell the truth. And so an example is, my friend told me the defendant stole it. My friend told me. And so that's hearsay because you don't know. You just are repeating what somebody else said. So in that situation, the phrase that you say is objection, hearsay. Objection, hearsay. The last one is objection speculation. So let's say the witness is being asked to talk about something that they just don't know. So here, an example of this would be, what was the defendant thinking at the time? What was he thinking at the time? I don't know what this person is thinking. I have no way of knowing that. So that would be asking me to guess or to speculate. Or if me as a lawyer, if you start asking me questions about medical things, what was the defendant's medical condition? I'm a lawyer. I don't know. I'm not a doctor. And so you can say, no, the phrase would be calls for speculation. Objection, the question calls for speculation. It means you're asking somebody something that they just don't know. So those are the main objections that you should be aware of when you're moving forward with your cross-examinations. I want to just take you through a hypothetical case, and then if you have the time, I encourage you to try to go through this case and then try to write like 5 or 6 cross-examination questions. So here, for instance, are some facts. Let's say the person is sitting in a busy cafe and she goes to buy her coffee and she leaves her wallet on the table. Then her wallet disappears, and at some point she saw the defendant near her table. But let's say that when she went to buy her coffee, she wasn't wearing her glasses. The cafe was crowded and noisy, and the victim, the person, never actually saw the defendant take the wallet. And so let's say the defendant is saying, well, I walked past the table, but I didn't steal any wallets or anything along those lines. So let's just say that is your situation. What I would like you to do is to now write a cross-examination, very simple cross-examination of the victim to try to emphasize what you see as the problem. So good luck with that, and I appreciate you taking the time to watch this video, and I hope that it was useful for you.